Hey everyone, and welcome back to my channel. I'm Johanna Chandler, your Central Florida real estate agent, and today we're diving into a topic that affects so many families, but often feels overwhelming: probate law and what it means for inherited real estate. I'm joined today by someone who's going to make this complex topic much clearer for all of us. Meet Kimberly Soto, an estate planning and probate attorney right here in Central Florida. Kimberly is the founder of the Soto Law Office in Altamont Springs, and she's been recognized as a rising star by super lawyers for multiple years running. Kimberly, thank you so much for being here today. I know our viewers are going to get tremendous value from your expertise.
Thank you so much for having me. This is a really important topic that I don't feel like a lot of people talk about, because I know it can be difficult sometimes to talk about what happens when someone passes, but it is a really important topic to understand your rights and what your family, might be going through, and maybe things that we can avoid having your family go through.
Yeah, perfect. So now before we jump in, I want everyone watching to know that while we're covering general information today, every situation is unique. So definitely consult with qualified professionals like Kimberly for your specific circumstances. So let's get started with the foundation. Kimberly, I call you both.
I answer to either, but normally Kim.
Can you explain what probate actually is in the simplest of terms?
Yes. So probate is a court process. So when someone passes away with something that they own in their personal name, like a house, so they've passed away and they own it on title in their personal name, that asset is part of their estate, which will go through probate, and then a judge will determine who inherits that asset.
Okay. Well, I mean, a question that I get sometimes from some families is that when someone inherits the property in Florida, does it automatically become theirs, or do they have to go through this legal process?
Great question. So we have to look at how the property is titled. So if I pass away in Florida with my house and I'm the sole owner of it, my property does have to go through probate. If I have a will, my will tell the judge who I want my property to go to. So I can say in my will that I want my real estate located at XYZ Drive to go to my two children equally, or I want it to go to a not for profit, maybe a friend or a neighbor. So my will indicate to the judge who I want the property to go to. If I don't have a will, then Florida statute is going to determine who my property goes to. It will still go through the probate process, and then a judge will make that determination by looking at Florida statute. And that depends on whether you're married, whether you have children. If you don't have either of those, then we look to further family members.
Okay. So, I mean, there's definitely a process involved. So, how long do you think this, or do you know that the probate process usually takes when real estate is involved?
So the probate process varies greatly from case to case. So there is a lot that goes into it. So at the beginning, we have to decide what type of probate we're going to file. The two most common types are going to be either a summary administration or formal administration. Those are going to determine a lot of factors, such as when the decedent passed away, how the value of the non-exempt assets, if we need a personal representative appointed to either, maybe challenge any creditors that we think are going to show up in the case, or if there are any claims that a personal representative needs to bring. Summary administration is usually going to be faster than formal administration because it has different requirements. It has fewer requirements. But an estate has to qualify for summary administration for us to be able to file it as one. So that's why sometimes, even if we would like to file as summary, we have to file as formal because we do have to follow the jurisdictional requirements. Summary administration, I usually say, can take, around 4 to 6 months to complete. Formal administration, you're usually looking at a solid year. Sometimes you can have it completed in 8 months. And then if there are any kind of issues that come up where the personal representative has to challenge a creditor claim, or file a lawsuit against someone. Maybe maybe the personal representative needs to actually file an eviction lawsuit against a tenant who's living in one of the decedent's properties that's now part of the estate. So that can definitely elongate the probate. And so you can be looking at a few years for a formal probate if there are some issues that need to be resolved through the court system.
Wow. So when you have real estate, it automatically requires probate in Florida?
If the person passes away with it in their personal name and they don't have any types of deeds that automatically pass the property to their heirs outside of probate. And so I can go into those examples too.
Okay, go for it.
Yeah, so when you do your estate planning, it's definitely important to remember about your real property. That also includes, your homestead where you live, any commercial or residential buildings that you have, any vacant land, and the big one people forget is timeshares. So any deeded timeshares, you can also take those into consideration when you do your estate planning. One common type of deed is a deed where spouses are listed on the face of the deed. So, maybe, Beth with her husband, Jonathan. So on the face of the deed, it lists them as husband and wife. Once one of them passes away, the surviving spouse automatically inherits the entire property. And all that needs to happen is the short form death certificate of the decedent being recorded. So that is no probate. It's just recording a death certificate. And that's for married couples whose deed indicates that they are in fact married. Another option is called with right of survivorship. That's for non-married couples. So for examples, if I wanted to add my child, let's say I have one adult child, I want to add them onto title with me. So I have an attorney, preferably, not yourself and not someone going on Google, draft a quitclaim deed, adding my daughter onto property with me. And we added on with the language that says as joint tenants with right of survivorship, so that if one of us passes, the decedent's death certificate is recorded and then the property automatically passes to the survivor. So once again, there's no probate. It's just simply recording one document in the public records where the property is physically located. The negatives to that are you are adding someone onto title. So you are giving up part of your ownership in land. So if I add on, let's say my 2 adult children, we would each own the property a third, a third, a third, if that's how I add them onto title. Or I could retain 90% ownership, add them on as 5% each. But I'm still adding someone else onto title. So the third option that we have is a ladybird deed. So that's an enhanced life estate deed. It is a type of quitclaim deed. And what that does is that allows me and or my husband, if I have one, or my spouse or a co-owner of property, we can continue to own the property while we're alive. And then only once all owners pass away would it pass to what we refer to as the second party. So if I'm the sole owner, I would have the property and own it myself while I'm alive. But upon my death, it would go to the second party, which could be my adult child, my 2 adult children, 50-50, a trust that I've created, a not-for-profit, a neighbor. So we really have a lot of room to play with it. And for a married couple, if spouses jointly own the property, it would only pass when both of them passed away. So ladybird deeds are really great tools for estate planning and avoiding probate.
Okay, perfect. What do you see are the biggest challenges when someone does inherit a property in Florida?
So like we talked about how long probate can take, it's when someone passes away, there are still bills that have to be paid. So how are those going to get paid? How is the electric going to get paid? The real estate taxes, if there's an HOA or condo assessment. While the property is going through probate, if that's what's required, how are these bills getting paid? Because the mortgage company is not concerned with the fact that the owner passed away. They're concerned with the fact that their monthly bill needs to be paid. Otherwise, they can start foreclosure proceedings. Right. Same with an association, same with your real estate taxes. So it is important to actually, from the practical side of it, that's not really, it's not a legal consideration so much as a practical consideration. How are these bills getting paid, especially for properties that pass down from generation to generation? if, let's say, my mom passed away and I live with her and my daughter lives with her and she's the one who was in charge of all of the bills. Well, when she passes away, if she didn't do her estate planning, her property has to go through probate, and then her bank account that has, 20,000 in it that we were relying on to pay also has to go through probate. So then I don't have access to those funds immediately. It can take months to just kind of figure these things out. Because once someone passes away, you are dealing with the emotional workload, right? There's a lot that goes into when someone passes away. What does that look like for the family members? So by the time they get to me, even for the consultation, the person may have passed away 2 months ago. So is that 2 months that these bills weren't being paid? Is the water still on? Is the electric still on? What's happening? And then we have to do a significant amount of paperwork if the property has to go through probate, and then eventually we will have access to the funds, but that can certainly take 6 to 8 months. So that's one of the practical concerns, is financially what's going to actually happen to that property.
So what options do they have when you have all of these bills paid? When they come to you, what are the options?
So a couple options. One is, before the person passed away, if they can list a beneficiary on their accounts, on their financial accounts. So if they list a POD, which is pay on death designation, through like their bank account, their checking or savings account. And those are forms that each financial institution has. They all have their own individual forms. So for example, if you bank at Bank of America, you would just contact them, your local branch, and ask them for their POD forms, their beneficiary forms, and then you can list someone who doesn't have any access to your account while you're alive. But when you pass away, any funds in that account will be given to whoever you list as your beneficiary. And
Oh,
usually you can list multiple people and you can do different percentages. So then they have automatic access to those funds to be able to pay the property. Or one of the heirs, let's say when my mom passes away, that she has a property here in Florida that me and my sister are going to inherit 50-50.
right.
It has to go through the probate process, though. One of us could elect to pay those bills and then be reimbursed at closing,
Okay.
or through the probate process, depending on the specific facts.
Okay, excellent. So, let's say, for example, the property is set to be sold and the family just can't agree as to how it's split, and because mom didn't leave a will, what happens at that point?
So, mom didn't leave a will, and let's say it's going to five children who just aren't in agreement with anything. So, that's a very difficult situation. So, a couple of different things can happen. If let's say it's mom's homestead property, because homestead has a lot of unique rules in Florida. We could probably talk about homestead for days and days and days. So, if it is mom's homestead, what the court should be entering is an order of homestead, having the property go to whoever mom's heirs are. So if she's not married at the time of her death, it would go to her five children equally. Those five children, that order of homestead is what actually gives them title to the property. So the order of homestead is equivalent to a deed, and that's what's recorded in the public record. So now those five siblings own that property. If they can't agree on what to do with it, the siblings who want to sell, whether it's one, two, a majority, or four of them, they can file what's called a partition action against the siblings who do not want to sell, and can usually force the sale of the property. So in those cases, we recommend usually that a special magistrate is appointed, which is usually a realtor or a broker, and they are the ones, the court directs them to actually handle the sale of the property. So the siblings no longer can interview realtors. They no longer have to sign a listing agreement. They don't even have to review the contracts. They won't sign any closing documents. The special magistrate is appointed to handle the entire sale of the property. And then once the property is sold, the proceeds will be delivered to the siblings, to the owners, in their appropriate shares. If one of the siblings has been paying the mortgage, or has been paying maybe some of the renovations that were necessary to sell the property, we can ask for reimbursement of those fees as well. So a partition action in that case is most likely what's going to happen.
Okay.
If it's not mom's homestead, like let's say it was a rental property that she had, we
Okay.
can it can be handled a couple of different ways. So either the personal representative in the probate case itself can ask that the property be sold, and that they have the permission to do it. So they would ask the probate court that they be allowed to list the property and sell it. And then the proceeds become part of the estate assets and would go through the regular probate process of whatever is kind of happening in that case.
Okay. So, from a real estate perspective, I also see families who want to sell inherited property, but aren't sure about the condition or value. What advice do you give them?
That's a tough one. So until an order of homestead is entered or a personal representative is appointed, no one actually has legal authority over that house, because it's in someone's estate. So someone has passed away and title is in their estate, and no one has the authority over that property. If everyone is getting along, and so if all of the siblings who are going to inherit, if they can all agree that one person should go to that property, or a third party, like a realtor, and they all give permission, then that person can go to the property. However, right, they are taking a risk in that they don't actually have legal authority. It's more one of those things where they have practical authority. But if anything did happen while they were on the property, that would definitely be a concern. So if it is something where the property has been vacant for 3 years in Florida, I would highly suggest waiting until we get the appropriate legal paperwork in order, so that then someone has permission from whoever is either the legal owner or legally in charge of that property to access it. But that can definitely be, a concern. I mean, someone can always do like drive-bys of the property. You can always drive out to the property and see it. Maybe ask neighbors if they have any information on the property. Have there been tenants there? When was the last time they saw someone there? To try to gather information that way.
Do you recommend getting an appraisal beforehand?
I guess that would depend on what what the heirs want to do with the property. If they truly do not know what to list the price at, then yes, they can certainly get an appraisal, so that they're not just listing it at maybe a price that everyone's guessing without even seeing potentially seeing the interior, and this is what you're discussing. And then getting an appraisal done so that you actually know what it could potentially appraise for once you get a buyer, because no one wants to be under contract and then 30 days from now find out that it doesn't appraise, and then the contract can't close, or the purchase price has to be drastically reduced. So appraisals are always, useful tools.
Okay. Now, something that always surprises individuals whenever they're inheriting property is the taxes on inherited properties. Can you break that down?
So I can't talk about taxes only because I'm not licensed in tax law. Yeah,
Oh,
so
oh,
stay
because
away
that's
from
a question that I always get. Is like, okay, I'm so surprised that the taxes are different than, what they've been paying.
Yeah, and that's most likely going to have to do with what exemptions they had. So, what exemptions the decedent had, right? Was it their homestead, and now it's been maybe stuck in the probate court for 3 years, so no one owns it, and certainly the person owning it doesn't live there anymore. So, if they lose like a homestead exemption or maybe a veteran's benefit, things like that. So, yeah, taxes can definitely come into play. So, I do always recommend that they speak with an accountant, a certified public accountant, CPA, get some answers on what it looks like on the other end.
Right. No, that's perfect advice. So, and I've heard some people say that you can so avoid probate with the right type of deed. Can you explain a little bit about that?
Yeah, so those were the types of deeds I was talking about. So, like if a husband and wife or a spouse, co-spouses own the property, if there's a joint tenants with right of survivorship language in the deed, different types of ladybird deeds, and if you own it in like a trust or a corporation, because like a corporation or an LLC and a trust, these are like fictitious entities. They can't pass away. So if the owner of the property is an LLC, you would look to the corporate documents to see who once one of the principals passed away of that company, whose interest that portion of the company would go to. So there's lots of ways to avoid probate, and that's definitely one of the tools that we use when my clients come to me for estate planning. A big part of our discussion is how can we avoid probate for all of their assets, and so that's definitely a big part of the discussion.
Okay, I mean, and that certainly adds in when they add the children into the deeds, like you were saying. So that sometimes can go ahead and avoid a lot of the probate when you start adding the children into your deeds.
Yep, and the different types of deeds are, really, really dependent on the situation and the facts involved. So, I what I do is I go over with my clients at the end of the day, what do they want to accomplish? Because then that will tell me how to accomplish it. So if it's, yes, when I pass away, I want this property to go to my daughter. Okay, that's a ladybird deed. Or if it's when I pass away, I want the property to be for the benefit of my three grandchildren who are 3, 5, and 7 years old. Well, then that at that point, we're probably talking about a trust. So that because you don't want the property to go to a 3 year old, you want the property to go to a trust, and then you have a trustee manage the property for the benefit of those three grandchildren. So really, what is the intent that they want to accomplish, and then I figure out how to do that.
Right. So perfect. Let's not go to Office Depot and get like the quick claim deeds and all those different forms there. Don't do that.
Please don't do that. And real estate is usually someone's most valuable asset. So please don't DIY real estate. Talk to a licensed real estate attorney and please make sure that it's being done correctly because I will tell you, I've gotten, calls from people who we can't help them. There are things that I cannot fix. For example, if I were to add on my two children onto title, so I get a quick claim deed off the internet and I add my two children onto title so that the three of us own it with joint as joint tenants with right of survivorship, and they're 10 and 12 years old. When I then 5 years from now, I want to go ahead and sell that property. If they're both, let's say it's 4 years from now, so that they're both still minor children, I can't sell that property with just my signature. And what's even worse is the court has to appoint a guardian over each of those minor children's property to be able to sign on their behalf. So a guardian of property is a very expensive process. So even though I'm the biological or adoptive mother of these two children, I can't sign for them
Right.
because they own real estate now. I have to get a guardianship over each of them. And then if we own the property a third, a third, and a third, their 2/3 funds from that property are going to be protected for them. So I can't even spend that money to buy another house. So please, yes, don't add someone onto the deed without speaking with an attorney and really understanding what the ramifications are.
Right. So it's not just so simple, like let me go ahead and add my kids onto the deed. You really
Yes.
think about exactly what you're wanting to do.
And a lot of times when people do their own deeds on the property appraiser, they'll have like the short form legal description, which is like a few like letters and numbers. That's not the legal description that we want to use. We want to use the actual long form legal description. So this is just a lot of ways when people do it themselves that they mess up because they don't know.
Right.
And like I said, this is usually your most valuable asset. So it's definitely worth speaking with an attorney.
Yeah. And then in real estate, just one number or one letter off on the entire legal description, you're basically not buying or selling that particular property. It could be somewhere else. So
Yep. And then you're ending up at probably like quiet titles down the road, which are expensive. They're thousands and thousands of dollars. We had one where the company who sold the property was spelled incorrectly by, I think, two letters were transposed. Back when it was sold, there was only like one company in existence that even had a similar name. But when it was, I think, 20, 30 years later, when the owners went to sell it, there was about, I think, 12 companies that had such similar names that
oh,
the
wow.
underwriter for the title company required us to name all 12 of them. It was uncontested in the sense that none of them stepped forward to say, no, we really think we own the property, because of course that's not what happened. The property was clearly conveyed, it was clearly sold, it was clearly purchased. But in order to clear title, I had to notify all 12 of those companies, which costs, just the costs alone on that, because we have to notify them in a specific way, were a few $1,000s. So these lawsuits can get very expensive. So really having someone who knows the ins and out and knows what can happen if things go wrong is really important.
Right. Perfect. So let's go into busting some myths. Here's the big one I hear all the time. If a property is in the will, does that mean it avoids probate?
No, I that is the most common one I probably get too. So a lot of people think that because I have a will, my estate and my property don't have to go through probate. So that's not true. So like I had talked about before, what the will does is your assets still go through probate, but then the will tells the judge who they go to versus being determined by the legislature by Florida statute. So just having a will doesn't avoid probate. It's how your assets are titled and whether there are beneficiaries on them. So if I have a house, and let's say I did a ladybird deed, so that house goes to my sister when I pass away because that's who I listed on the deed. Well, that house is taken care of and goes outside of probate. On my bank account, let's say I have it go to my two children equally. I list them as a POD beneficiary. So they'll receive that asset outside of probate. But then I have an investment account that I just never listed a beneficiary on. That investment account, because I own it in my personal name without listing any beneficiaries, goes through probate. And then the court will look to my will to determine who I want that asset to go to. So yeah, just having a will doesn't avoid probate. And we still do recommend wills because they're good. I like to think of it like insurance. We don't want to use it, but we have it if we need it. Because wills do so much more than just saying who you want your assets to go to. They can put out your burial or cremation instructions, what happens to your pets when you pass away, who are they going to go to, guardians for your minor children. So wills are still really helpful tools. And then we just hope that we don't have to use them, because if we do have to use a will, it's because something went wrong somewhere. Either an asset needs to go through probate or someone is fighting about something. And so that's when the wills come in. So that's kind of them in a nutshell.
I mean, and the will also has like what you want with your digital stuff, because now we have all of our pictures and videos and all that stuff. So that's important too.
Very important. Yeah. So wills are just great tools to have.
So when there is no will, how does Florida law treat situations when someone leaves behind property, but there is no will? Like, who decides who gets what? Is it the judge?
So the legislature has already decided. And then the judge is the one who puts kind of the final ruling on it. And so, for example, if I pass away and I'm married, and let's say I have no children, then my spouse will inherit everything. So if I pass away with a spouse and no children, my spouse gets it 100%. And a big thing to remember here in Florida is we do not have legal separation. So even though I am estranged from my spouse for the last 15 years and they live in New Jersey, they are still my legal spouse. So they would be the ones who would inherit my estate.
Oh, wow.
Yep. Yeah, that's we
A lot of
get
people
those
know that.
Yep. We get those calls actually fair, like often enough that it is a surprise each time. And so now the spouse could disclaim their interest. They could choose to not inherit, but legally they would be entitled to. If I'm not married, then my assets would go to any of my children in equal shares. So if I have three children, it would go a third, a third, and a third. And the courts cannot look to anything else besides whether they are my legal, either biological or adopted children. That's all we're looking at. So we're not looking at whether they are good with finances, whether they're in jail, whether they have a drug problem. We are not looking at any of that, whether I hadn't spoken to them in 20 years, because I didn't do a will. So Florida statute is saying this is how my assets are going to go. If I have three children and I'm estranged from one and I only want two to inherit, I have to either do my estate planning by putting beneficiaries on different accounts and or doing my will. If I create my will and I disinherit that one child and say all of my assets will go 50-50 to my two other children, then absent a challenge to the will, that's what will happen. As long as the will is validly executed, then I can supersede Florida statute. So Florida statute is just the default. So it depends. And then, so it depends if you, let's say that you don't have a spouse and you don't have children, it would go to your parents. And if you don't have them, it would go to your siblings. And after that, we start reaching out to further and further family. So we're going to try to find someone related to you.
Okay. So let me ask you this. I mean, when we're talking about, all of these surprises, that people may get because they don't understand what had happened when it comes to probate, especially, being estranged from a loved one or whatever the case may be. And legislature already has determined what to do. When people are coming down and they're doing their estate planning, like what are their biggest mistakes? Like, if you were to say you should do this first, or do the top three things whenever you're doing estate planning, like what would be your recommendation?
So you want to get a list of all of your assets, right? All of the assets that you own. So your checking and banking account, your checking and savings account, your investments, 401k, life insurance policies. People like to forget about those. Get a list of your assets and then decide who you would want them to go to when you pass away, in what percentage. And then if that person passed away before you, what would happen to their share? So if I have 3 children and 9 grandchildren, if one of my children pass away, would their share go to my surviving children, or would it go to their lineal descendants, so their children?
Mhm.
So figuring out who you want your assets to go to, and then what would happen if someone predeceased you. And then also looking at, a big important thing is, are you trying to leave anything to a minor child? If you do, we're most likely going to be talking about a trust, because of the whole concern that if a minor inherits something in Florida, they don't have the ability to inherit that. A minor can't open up a bank account and then receive a life insurance policy check. So then someone, either related to them or who knows about them, is going to have to open up a guardianship over that asset or those funds. So when we're talking about minor children, we usually prefer to leave it to them in trust, where we can appoint a trustee to manage it, so that we're not having to file for guardianship, which comes with a lot of requirements and also annual accountings to the court. So a trust is usually the better route to go when you want to leave assets to a minor child.
So from what I'm hearing on everything that you're saying, it's like, don't wait too long. Like, you should be doing things right now, to go ahead and prepare yourself for all of these situations that may happen. So what are the steps that they need to be taking, like right now, is putting together that checklist that you said. And what would be like the first thing that they should do once they have that checklist?
Definitely consult with an estate planning attorney. I would highly recommend that, because once you have that list, even if you think it's simple to just go to the bank and put beneficiaries on, there might be some intricacies that obviously we can't cover every single situation today. And so I do definitely recommend going with an estate planning attorney and saying, I've made my list of assets. Here's my plan of who I want them to go to. What things am I missing? What roadblocks am I not thinking of? Because depending on the type of asset and who you want them to go to, there are different estate planning tools that we can use. And of course, there can be tax implications too. So always keep that in mind, depending on, the value of the estate.
Right. I mean, and life can throw you some curveballs. And, certainly whenever we're doing estate planning, it's not like a set it and forget it type of a situation. So how often do you think that people need to be reviewing or updating? What is your recommendation?
I recommend to do a thorough review every 3 years. I cannot tell you the number of times that people come to me and they're like, we swore that 10 years ago, our documents listed A, B, and C in that order. And B and C aren't even on there. You do just forget, right? We're a forgetful species. So when you do your estate planning documents, actually peel those documents out of wherever they're hiding and physically flip through them and put eyes on them to see, who did you list as your agent under the power of attorney? Who's the alternate? Have they passed away? Have they gotten remarried to a spouse that's now influencing them in ways that you disagree with? Are you just not in touch anymore? Have they been estranged from you? Are they not that close? Is that not the person who you want to make decisions for you? So definitely actually peeling out your estate planning documents. I recommend about every 3 years, to look at them to make sure that they are your wishes, because these are really important personal documents for each of you. So making sure that they're done the way that you want them done is very important. And please, ask your estate planning attorney questions. Make sure that those documents are what you want them to be. They're going to the people you want them to go to. The people who you want to be in charge are in fact in charge. You're never going to ask too many questions. You really need to be comfortable with your estate planning attorney and with your estate planning documents. That's the most important part.
I mean, all of that's important advice. And definitely, so keeping good records, going over your information, so important. Now, who do you tell? Like, I know for me, sometimes I do some things and it's important documents and I can set them away and it's like, oh my gosh, where did I put it? Where did it go? You know, if sometimes if I tell my husband, he'll was like, oh yes, remember we put it here and there. So what do you think? We should tell whoever's on the will where our documents are? What's your recommendation?
Yeah, it's going to come down to who do you write trust with that information? Who do you feel comfortable sharing that with? So we recommend keeping all the important document in one place, whether that's in a safe in your house or in, one maybe desk drawer that you have that maybe can lock if that's what you feel comfortable with. And then, yeah, you can let the people around you know who you trust and feel comfortable with. I mean, even a neighbor, because a lot of times when, if the children, let's say, don't live here in Florida and the parents pass away, the people who the children are going to talk to are the neighbors. Hey, how close were you with my mom? Do you have any of this information? Do you know where she kept these documents?
Right.
Definitely, giving them your estate planning attorney's information. Because a lot of times, right, when someone's passed away, the next of kin can call us. And as long as we either have been given permission to speak with them or they're the personal representative that's listed or the trustee that's listed, we can then give them the information. We always obviously are bound by attorney client privilege. So that's why they have to really fall into one of those categories. It has to be someone who has the actual authority for us to be able to give them information, but we can be a great source. So definitely keeping the estate attorney's card in with the important documents, or a lot of documents will have the estate attorney's information actually on them, just so that it's easy for the family to get in touch with us.
Okay, perfect. So so much information. A lot of the viewers may be overwhelmed. You know, what are
Yes.
your final thoughts?
Estate planning is very important for everyone. It does not matter how many assets you have. It is really, truly important for every single person to do their estate planning and not to wait, until very late in life. There are people at 30 years old who have strokes and then are unable to make decisions for themselves. And when they don't have a power of attorney in place, and they have, let's say, a few properties that they own, maybe one or two businesses, bank accounts, the family who's around them has to then get a guardianship over them to be able to make any financial decisions. So you're never too young, as long as you're a legal adult, to have estate planning documents. So it really is important, once you're 18, to really start thinking about that. If you're going off to college, having a power of attorney and a healthcare surrogate for your parents that lists, your parents or your friends, whoever it is that you want to make decisions for you. Maybe a couple who has had children. So you have some minor children, you can do your estate plan to see if something did happen to both of you, what would happen to your children, who would care for them and how would they be cared for. And then of course, when you're, later in life, if we are looking at concerns about health or anything like that, it's really important to start looking at and doing your estate planning documents.
Okay, thank you. I mean, this has been incredibly valuable information. I mean, in my mind, I'm thinking, you could do a whole series as to what does a personal representative need to do, when they're aware that they're the personal representative. Like, do they need to get this document, that document? I mean, it's so much stuff that,
Yeah.
is so involved within probate that it's not like, oh, probate, here we go to the court. It's, there's so many different steps in there. But
Yep.
I appreciate every piece of information that you've given, and you're certainly in sharing your expertise.
Yes, thank you so much for having me. This is a topic that, I do love to talk about because I think it's so important for people to understand and be aware of what their options are, and what the ramifications are of not planning.
Right. Absolutely. And to everyone watching, if you're dealing with inherited property or thinking about estate planning, don't do it alone. Kimberly and her team at the Soto Law Office are here to help you. You can reach them at 321-972-2279, and I'll put their website link in the description below. If you're in Central Florida and you need help buying, selling, or managing inherited real estate, I'm here for you too. My contact information will also be in the description. If this video was helpful, please give it a thumbs up and subscribe for more Central Florida real estate content. Thank you so much, and we'll see you on the next video.